Morning student. Today we will discuss the rest fundamental rights. Earlier we have discussed the fundamental right that is of right equality which is given in your article 14 to 18 of the Indian Constitution. Just like book has number of pages, Indian Constitution has article and each article has its own relevance and significance. Now we will study directly right to freedom which is given in your article 19 to 22. By liberty, we means freedom of thought, expression, speech, but this does not mean every citizen is free to speak anything, so they are always subjected to some limitations. Every person is free, every person has been given a freedom of speech and expression, so that everyone is free, so whatever they want to speak, they can speak, plus, they are free to express through their speech and but this does not mean that they have been given license to speak anything. They are always restriction, they are always subject to some limitation. If any person who is speaking, and by speaking of that particular person there is an enmity among the religious group, plus that person is been responsible for the hate speech, that person will be held guilty. As we know that there are our fundamental rights are not absolute, there is always some limitations in it. So there are various other rights which are given under Article 19, like freedom to form association, freedom to assemble without arms, freedom to do any profession provided that is lawful, freedom to reside in any part of the any territory of India. Like if we want to settle in Chhattisgarh, we can move to Chhattisgarh. Now, next, everyone has a freedom of speech and expression. Everyone has right to life and liberty. Suppose if a person is arrested, then he should be informed about his ground of arrest. He can approach his lawyer, and the person has to present before judge within 24 hours. Article 20 basically speaks that if any person is arrested, he has a right to be informed on which ground he has been arrested. For example, if a police arrest a person for the murder, he should be informed that he has been arrested on the charges of the murder. Plus, that accused person which has been arrested, he has a right to approach his lawyer. Plus, that person has to be present before a magistrate or a judge within 24 hours. So these are the rights of the accused. Now, Article 21 speaks about right to life and liberty. All the things which are essential for living, for example, right to electricity, right to have a water, right to privacy, right to breathe in the air, all the rights which we think are essential for living, these all rights come under article right to life. Article 21A speaks about right to elementary education. So these all are the fundamental rights which are to be given to Indian citizen and which has to be protected. Now, Article 22 speaks about preventive detention. In a normal procedure of law, each person who has been arrested has to be presented before judge within 24 hours, and if that person has to be, if judges thinks that the person has been arrested illegally, the person will be set free. If not, then custody will be given, and person will be arrested for a longer period of time. But in abnormal condition, when government think that any person should be that a particular person should be arrested on mere suspicion that that person will be do some unlawful activity or some other illegal activity which will be danger to the India, they can arrest that person, and in that particular case they can detain person, and in normal procedure of the law will be not followed. For example, he will be not present before the magistrate within 24 hours, government can illegally detain that person. So that is why it is called preventive detention, to prevent that person from doing any illegal activity. So Article 19 to 22 it speaks about right to freedom. Now Article 23 to 24 speaks about right against exploitation. Earlier there was exploitation of underprivileged or deprived section of the Indian society. They were subjected to do forced labor, or they were not even paid. There was a buying and selling of women and child labor. All such activities are now subjected to the constitution and they are declared illegal. In previous time we know that there was a slavery, there was a free movement or free sale of the women's and child for that were later on subjected to slavery. But now this all things are being declared illegal, and various law have been formed like child labor amendment, and to stop basically child labor. So article 23 and 24 speaks against right against exploitation. Now article 25 to 28 speaks about right to freedom of religion. India has diverse religion, and every religion, every particular person has right to choose his own religion, plus he has been given right to practice his religion plus propagate his religion, subjected to public order, morality and health. For example, sati is a practice of Hindu uh, in early time in early time, but that particular practice goes against the morality and health, so this practice was declared illegal. So government can intervene in we can say religion practice, provided that they are harming that public order, morality and health. So as long as and one person is free to choose any religion. If someone is born Hindu religion, he can choose to become a Muslim or Sikh, provided that he is choosing on his own choice. He is not been forcefully, or he has not been forcefully pushed to choose that particular religion. Now 26 article simply speaks that every religious denomination has right to administrate their own religious affairs. For example, if we want to go in Gurdwara, we have to cover our heads. So this is the decision of that Gurdwara committee, administration of Gurdwara, and government will never interfere in their religious affairs. Now next is cultural and educational right, that is article 29 to 30. So there are minorities which have common language culture that is different from the language culture of other religion which is in majority. So as we know, India is a diverse country and India believes that diversity is their strength. So to protect the culture and language of the minority, this article were added. So in this article, special provisions are being made by the constitution that minority does not feel themselves alienated and can protect their own language, culture and script. For example, there is a tribe of 500 to 600 people living in Odisha. Now they have their distinct culture, language. They have been given the right to conserve that same, so that they should also feel that they are a part of this India, and this special rights has been given by the constitution to them, so that they can protect their distinct culture, language and script. Government has provided fund to help them in protecting these all things, plus preserving them. So minorities can also establish their own education institution like Gurdwara Senior Secondary School. So these are the education institution which they can establish, plus government will be providing funds to minorities like Islam, Muslim, Parsi, Jewish, Christians and Sikh. So they have been given the funds to establish education institutions, so that all the minorities feel that they are having given the power, they are like the same which is in majority. So basically this article of the Indian constitution want to conserve the diversity of this nation, that is India. Now right to constitutional remedy, which is given in your article 32. Right from the lecture we are saying, if there is a violation of a fundamental right, the aggregated person can approach the court. So this article gives the power to person to go to the court of law. So this article give right to citizen to approach High Court or Supreme Court if there is a violation of their fundamental right or for restoration of the fundamental rights. Court will be giving the order, and that are called writs. So first writ is habeas corpus. The writ is passed by court for checking the legality of arrest of person. When this writ is passed, the detained person has to present before the court, and if the court finds that person is illegally detained, he can be set free. So if a person thinks that he has been illegally detained by the government of or any private person, then the Supreme Court will be issuing a writ to present that person before them, and the court will decide the legality of the arrest. If they say that person has been illegally detained, he can court will set that person free. But if they find that the person has been illegally detained, then the court will not interfere basically in this. Then another writ is mandamus. This writ is issued when the court thinks that an official holder is not doing his duty, which he is obliged to perform. So any official person who is not doing his constitutional mandated duty, if court think that he is unable to do that duty, they will issue a writ of mandamus and will order that person to do his constitutional mandated duties. Now next is prohibition. The writ is issued by higher court like Supreme Court and High Court to their subordinate court if later one thinks that a former are considering case which is beyond their jurisdiction. So if the subordinate court like district courts are hearing that case which is not coming in their power, then High Court or Supreme Court will issuing this writ and will prohibit that subordinate court to issue to hear that case. For example, constitution related cases are usually heard by High Court and Supreme Court. If any constitution related case is being heard by subordinate courts, the former High Court or Supreme Court will issue that court, subordinate court to not listen that case. Then next is writ of certiorari. This writ is issued by High Court to lower court either to pass the order of the former or transfer the case pending toward them to former. So if there is a case which is pending in subordinate court, and the High Court or Supreme Court think that, or order that subordinate court to pass the verdict or judgment which has been given by High Court or Supreme Court to subordinate court, or either to transfer that pending case in subordinate court directly to High Court or respective Supreme Court. So the next and last writ is quo warranto. This writ is passed to check the legality of public officer. If court thinks that a person is holding the office but is not been entitled to hold that office, so that a person should be stopped from holding that office. If any person who is holding a public office and is unable to furnish the information or legal pages that show that he is the original holder of that public office, then this writ will be issued, and that if that person is unable to furnish the information, he should be immediately stopped from holding that office.